Welcome. I'm Tracy Lobertini, and this is Adam Bullock.
Hello.
Adam is an attorney, local here to the area. We are in East Tennessee near North Lake, and we're going to talk about several things. North Lake, probate, adoption, and we're glad you're here. Talking about adoption a little bit more, tell me kind of the process of how it works, especially with grandparent adoption. I think we were talking about that.
Yeah. So, there's a list of, several grounds for adoption that you can have in Tennessee. The two most common is 4 months of willful non-payment of child support and willful non-visitation of the parents.
Not contacting.
That's right, not contacting. And so, one question a lot of people have is, well, we haven't been in child support court. Well, that don't matter, because it don't take a rocket science to figure out you got a kid and that kid's got to eat. And so the Tennessee Supreme Court has multiple times said, well, you don't need a actual child support order to do that. And
how does that work with an incarcerated person?
So that's a great question. So if that person is incarcerated, technically that 4-month term starts 4 months prior to incarceration.
Okay.
And so, but there's other.
But if they were active until incarceration,
yeah,
then it would be hard to get that timing to be while they're incarcerated.
There's other grounds, but for that specific ground, the most common two, that would be difficult. And some of it depends on how long is their term of imprisonment. I've had one specifically in Anderson County where I think I don't have my book in front of me, but I think a term of imprisonment of more than 10 years is a ground.
Right, because that kid's going to be grown and gone.
Right. Yeah. And that person was actually in the federal penitentiary, and so we were able to get that done for that family that I was close with. But those are two of the most common grounds. And one thing we see come up, and sometimes the biological parents, they'll say, well, we and there's one specifically that's coming up that comes to my mind because we're getting close to the holiday. The mom in that case said, well, I dropped off an Easter basket. And so what the Tennessee Supreme Court says is token gifts and token visitation is not enough. So,
that's really good, because a kid doesn't need an Easter basket. They need any given Tuesday.
That's right.
I mean, just not a special day.
Yes. And so, and the Tennessee Supreme Court has said time and time again, those are token visits. If you have, grandma has the kid and you show up to eat Christmas dinner, that's a token visit. That's not really, you want to show up either way. That's not really meaningful to the child. And so we see that come up a lot. And, adoptions are the best thing we do as lawyers. But sometimes it's sad too, because mom and dad has kind of fallen through addiction or anything. But it's at the end of the day, what mattered. That is sad, and but we have to focus on, and society has to focus on what's best for that kid, to help that kid succeed, to be somebody who contributes to society in a positive way. They don't have to be a doctor, they don't have to be a lawyer, they don't have to be a real estate agent, but are they going to contribute to society in a positive way, to do the right thing, be honest, get a job, and be a positive person in our community?
It seems like to me most of the circumstances around an adoption on the beginning side would be tragic or sad, but on the end, it's got to be something to be celebrated, and you got to feel like you're doing something really good.
Absolutely. We should be celebrated, and adoptions are either really easy for us as attorneys to do, it's a lot of paperwork, or they're really hard. And I've had 2 or 3 now that have gone up to the Tennessee Court of Appeals, and we've successfully defended all those. We won at trial, and then we've won at the Court of Appeals level 2, and then they chose not to apply for permission to appeal to the Tennessee Supreme Court. And so, yes, that is good. Those are certainly happy moments for everybody.
It just seems like on the estate side, you're kind of wah, 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 wah.
Yeah. Yeah.
And then on the adoption side, it's a little bit more positive. So that's good.
That's right. And so let's talk a little bit more about estates, but one other thing is that's really a neat thing that people don't think of. If you have, if you adopt a child, is they get a brand new birth certificate. And so when that kid gets the birth certificate back, it says, dad is the person who adopted.
Oh, really? I didn't know that. Yeah.
Yeah. So even for me, so I was adopted as an adult, and so my stepdad adopted me, and it was a great thing. And I was out of town on a golf trip, and he approached my wife, who we already talked about, who's a lawyer, and so he was like, "Hey, we want to do this," and it meant the world to me, but it wasn't that big of a deal. But they didn't know anything about adoptions or anything like that. He was always awesome to me, my best friend.
Yeah.
But when we got that back, it said, Dad, Larry Tibbs, Mom, Glenna Tibbs, and then my name on it. So that's a really neat thing that we have to do.
Do you think that having the relationship with Larry that you've had makes you tune in a little bit more to the adoptions? It makes you tune in a little bit more, especially to the step-parent aspect?
Yeah, I think so.
And being a step parent to your fur baby.
Yeah, that's right.
You're a great role model, but do you think it tunes you in a little bit more?
Yeah, I mean, certainly it does. They just, every case list means a lot, obviously, but especially if it's a contested adoption, we really have to make sure we cross our T's, dot our I's, and stuff like that, because, somebody's life literally could be on the line, and to go back to mom or dad, or to go back to any situation that's not positive, for the child. And so, and people depend on us to do a good job. And, our goal by the end of the year is to have 200, 5-star Google reviews. I don't know how many we have now, but we're getting up there. And so, and all those are real. Besides the 2 that are not real, and one of the lady was like, we stopped in for directions, they were helpful. And I was like, that has nothing to do. And if we were helpful, why didn't you give us 5 stars? And we have no record of where that person showed up, and then another person, we have no idea either.
I have somebody from Johnson City that gave me a low review on something, and I was like, I don't even do real estate there, so yeah, I don't understand. And my name's kind of unique, so
yeah,
probably
exactly.
not
That's
confused.
what I was going to say.
Your name's kind of unique. I saw something the other day. A lady had a scan code on the back of her phone, a sticker, and I asked her for a business card, and she said, "Here, scan this." And it scanned her contact information. I could just save it.
Yeah, that's crazy.
Is that not? You could do a scan thing for your reviews.
Yeah,
on your phone.
That's right. Yeah. So we typically just we email a link to clients. Say, hey, we're a small business. We appreciate getting 5-star reviews, and it helps people find us. People who have not been in the legal system before, or people who have moved here at the lakes, like, shoot, we need to update our estate planning. Who's going to do it? Right. And they say, North Lake Probate or whatever.
Lawyers are hard to find because it's not like you're driving down the road and you see a gas station and a bank and a funeral home every day. You don't really. I mean, all those people that do sort of personal injury, they advertise a lot. But I know you've got a couple of billboards, which is big and fancy.
Yeah, we went to the Boy Scout dinner last Thursday, and I was actually shocked at how many people said that they have seen that. And, we wanted to get word out that my wife and I had joined forces, and that, we're trying to grow our practice. And one of them is set up I-75 going south right at the mile marker 128 or 129, right by McDonald's and Rocky Top or Lake City. And the other one is coming I-75 north just past Fox Toyota. And so
the exit 121.
That's 120. Yeah, the Clinton exit's 122, but it's probably on maybe closer to 123.
It's coming that
north.
way.
Yeah, and the other one's at 128, 129.
On I-75.
South, yeah. One's going south, one's going north, and so
that's a great way because a lot of people commute. It's amazing how many people from our area commute into Knoxville and back. So those are great visibility.
Yeah, and I just talked to the one going south today because it's set up on. And my mom works at Walmart, and so she gets there she works like 6 to 3, so she's there really early when it's still dark. And she let me know, she's like, hey, your billboard's not lit up. And so I had to contact the person who owns it, and they're going to have to install some more stuff. But we have a lot of people from Campbell County and Scott County and some even from Claiborne County that'll go down this way. And so it's important, for that billboard to be lit up because there's a lot of jobs, off the Clinton exit, a lot of factory jobs, and those people, we cater to them, and we have a lot of clients from down that way, but they live here primarily, or Scott County even, and work down there, so they may not know who to call or who to turn to when they need an attorney, and we want to be the attorney for them if it's an area of practice that we do.
Good.
Yeah, we talked a little bit about probates, and one thing I mentioned a term off camera called ancillary probate.
Yeah, and I don't understand that, so you have to tell me what that is.
So we do a few of those a year. So basically, if somebody lives in, we'll say Ohio, we have a lot of people that retire from Ohio. If they live in Ohio and they have an Ohio will and they just have like a lake home here, but they're not residents yet, and so something happens to them where a probate is necessary, where their residence is, which would be in Ohio, but they own a lake house here that would, be needed to probate, say a single person or something like that, then, a lot of lawyers up there, they'll contact me to open up what's called an ancillary probate. So that's basically in another jurisdiction. So,
so they may be probated in Montgomery County or Greene County or whatever in Ohio. Then they would need one in Campbell County.
That's right.
Here.
They'll have to have one here as well. And so the way that typically looks is they'll have to get a certified copy of that will, send it to me, and we'll work on getting them what's called letters testamentary. That's what says they're in charge. That they will just transfer that property pursuant to the terms of the will and do that. The last one I did was out of Claiborne County, but it was, property at the lake. They died in, I think these people were in Illinois actually, and so unfortunately they passed away. And there was some property down here that had to be probated, so we had to do it. There's no way around it.
One thing that's really funny, there is a county in northern Kentucky that a lot of my clients live in, Campbell County.
Yes.
And then they have a Campbell County here, and that gets really confusing on their property taxes and all of their different things. So I'm sure you will run into Campbell County, Kentucky, and Campbell County.
Absolutely, I have. We've done an ancillary probate from Campbell County, Kentucky, and
what are the odds of that?
I know what the documents look like, and for Campbell County, Tennessee, so usually they're on a different font or something like that.
You can tell.
But still, sometimes if the font's similar, especially if the county name's the same, it's like. Make sure. Did the Dennis Potter's office change their paperwork? Like, what's going on here? So.
I love it. So we talked about that from a probate, but one thing from a real estate perspective, we run into a lot of little problems when we're trying to sell property with someone thinking that they don't need to probate when they really do. Mm-hmm. B, not having a 10-care release because the people didn't actually have 10-care. So, when my dad passed away, first thing I did was say, we need to get, and actually some of the girls at your office helped me do that.
Sure.
We got a 10-care release. We didn't need to probate. He didn't have 10-care, but whether you have it or you're not. Can you explain a little bit about the 10-care release? Because that's a confusion for everybody.
Yeah. So in my experience, we've probated estates from obviously a lot here, Washington County up toward Johnson City, Hamilton County down toward Chattanooga, and basically everywhere in between. So technically in Tennessee, anybody that passes away over the age of 55, there has to be a 10-care release. So, but a 10-care release, basically what it means is it's long-term care benefits paid by the state. And so, in my experience, judges will not close the file. They don't care if that person's 155 or 25. They want a 10-care release in the file, and that just it's actually a lot better now. You can email it. They used to outsource it, yeah. But now you fill out a little form, you submit a death certificate, and any probate information you have. That's the first thing we do when we get a probate file. Or almost the first thing.
Is it just to protect the state against loss of asset of someone having a bill and then the assets being disposed of and then the state doesn't get paid?
That's right.
The bill that's kind of what I understand.
That's exactly right. I mean, but it's more for, it's kind of, it's not misleading, but it is a 10-care release because, in Tennessee we have a program, if parents make below a certain amount of money, their children are on what we call 10-care.
Almost like a Medicaid.
This is more of a Medicaid deal, but it's still called a 10-care release because if the state's paying it through Medicaid, it's really kind of a Medicaid release. And they're getting a little bit more aggressive. They hire a private attorney to kind of open up estates. And so the best way to look at that is, if you have an aunt that maybe never married, no kids, and she has a 100-acre farm, she spends 5 years in the nursing home, but she only drew $900 a month Social Security, she's going to have a great 10-care lien on that property. And so that would have to be satisfied before anything happened to that property, or it's,
at the time of the transaction.
Yeah, at the time of the transaction, because certainly the buyer would want to be, they can't get clear title without a 10-care release. And so if there is a release, certainly you need to, talk with an attorney to open up an estate to see if we can, work out a lower amount or at least help the property get sold, because there's certain expenses that come off the top first when you probate an estate. Attorney fees is one of those, thankfully.
Say you've got the 100 acres.
That's right.
And it's someone's aunt, and they have a $50,000 obligation to 10-care or to Medicaid, and you're going to sell it. So how does that look? Let's say you sold it for $250,000.
Yeah.
So the first $50,000 is going to go to Medicaid.
Typically,
okay.
but if there wouldn't be enough there, then technically the cost of the administration of the estate would get paid first, and I think the funeral, and then we would have an insolvent estate at that point.
Okay.
But yeah, if it sells for more than, they're going to go ahead and issue them a check probably from the closing.
Okay.
And then they will they'll file a release. At that point, they'll file a release with the court because they have their lawyers involved that says, hey, there is a claim. This claim was satisfied.
Okay.
And so.
And then that's how the buyer gets the clear title.
That's right. And it's important too. I actually had one recently out of Scott County where my client, who was great, she lived in the Atlanta area, and her mom had passed away in Scott County, but she was entitled to a settlement of some sort. And 10-care filed a claim that said it was, $30,000, $40,000, $50,000. And I've seen them as high as hundreds of thousands.
Wow.
But my client was adamant that her mom did not receive any sort of long-term care benefits through nursing homes like that. She was on regular 10-care, but none of that. And sure enough, I don't know what happened, but she was not, in fact, that, and they released the entire claim.
Wow.
So that's a rarity, but we were able to get back and show that, hey, she was in fact not at this nursing home at this time because her boyfriend had taken her home and took great care of her. But so that was interesting. We didn't know if it was actually paid out or not, but if it was paid out, it wasn't paid out on her benefit, and somebody got money. Yeah. And so, that's why it's important to have a lawyer, because they file a claim, they have to show when it was paid and all that stuff. And you talk to your client and say, hey, was mom or dad or aunt or uncle, were they at this place at this time? And if they say yes, the will kind of is what it is. And it's unfortunate. Nobody wants to see their parent or their grandparent or whoever, have to lose their childhood home to pay for that. The flip side of that argument is we live in Tennessee. We don't have a state income tax, and somebody has to pay for those services.
Right, for that bill.
Yeah. The bottom line is it sucks, but somebody has to pay for it, and either, they're going to have to increase taxes or something like that. And so.
And they're not turned away. That's
right. And they're not turned away. And so, but at the end of the day, it's unfortunate that so long as somebody, has care, that's what matters. That's ultimately what matters.
You're right.
Yeah.
So are there any other terms or things that you find people are shocked at, like ancillary probate or a 10-care release when the person doesn't have Medicaid? Is there anything else that shocks people about a probate?
No. However, the one thing that comes up more often than not, and I know you know this, is somebody will come in to see us and they'll say, unfortunately, mom or dad passed away, we're power of attorney, we got to do this. That power of attorney dies when when the decedent passes away. So what I mean by that is that power of attorney is no longer valid. So
I know that. So if they can no longer sign, you can no longer sign.
That's right. Yeah, if they're not here, the only real exception that I feel comfortable saying is, making. In our powers of attorney, we usually put a clause in there that gives the power of attorney authorization to deal with final remains. That comes up with cremation, burial. If there's a conflict there, so we usually put a clause in there to that effect. But yes, if you're acting as power of attorney for somebody, that power of attorney, in fact, dies with that person. And so you can no longer go to the bank to access the account. You can no longer, obviously, you will be making healthcare decisions, but that power ends. And that doesn't necessarily mean that you're going to be named as the executor or personal representative or administrator in the estate. Technically, if a person has the will, you're an executor or executrix if you're female. And then if they don't have a will, you're an administrator or administratrix. I just use the term personal representative because it's kind of all-inclusive with whether they had a will or not. It's just easier to say PR, personal representative.
Executrix, and it doesn't roll off your tongue.
It's hard to spell, too, especially I'm trying to write it down or whatever. But
personal representative is much easier for the layman to understand.
Yes, and so
one thing that we get a question a lot is, can we sell Mama's house if we don't have the probate isn't finished and we need to sell Mama's house? How can we do that? And we've done that before, but it has to have a judge's input, correct?
Yes, so almost always. Now, there's some wills that say, my personal representative, can do this without the authority of the court, and that's generally okay. It still gives pause if you're wanting to do a kind of an arm's length transaction. What claims have been filed? Is there a 10-care release? So it's important to know that sometimes you can, but it's best practice to have a judge's signature on that, especially if it's going to be selling for a lower amount, or selling for a lower amount, or kind of an arm's length transaction. I always like to, especially if everybody's in agreement. You don't have to go to court. I mean, I file a little motion and do an agreed order. Everybody signs it, and it's kind of protective of that. So
yeah, we've done that before.
And it's kind of a protector of CYA for you all too.
It is good to have that, and we've had them where they've held the money in the probate account or
in the court's registry,
in the court, and then that way we don't even have to worry that something's going to come back up at the end, and then there's a problem. So that's really my comfort zone.
Yeah. I do, I'm not against that either. Sometimes it's just easier, and when it is finished, you can do a breakdown of who's getting paid what. They can typically issue the attorney check out of that if there's any claims out of that, and just distribute the rest. One thing too is if there's claims filed in an estate, you need an attorney to do an estate. Of course, the attorney's going to say that, right?
Right.
However, what's important to note is that if you do that more so on the front end than the back end, because I've got involved in some estates where there's been pretty significant credit card debt. A lot of times, they don't submit, and my argument is the proper documentation to file that claim with the court. And so if I file an exception to that claim and set it for a hearing and nobody shows up, you don't have to pay that. And so the worst thing you could do is you come to me and say, hey, we're ready to finish this probate. So, well, what are the claims? There's $100,000 worth of claims. Some of them are medical, and some of those won't show up. They'll write it off. And then, it makes me sick to have to tell them, well, I couldn't have guaranteed this, but there's a pretty good chance we could have got this claim forgiven if we would have filed an exception to it. But you have a limited amount of time to do that, to file that exception to the claim or objection to the claim. It's kind of interchangeable, but it's just important to do that. As my grandparents used to say, don't step over $1 to pick up a dime. And so, get counsel when it comes to probate sooner rather than later. Don't say it's just some paperwork. We can do it ourselves. That part probably is true. You can fill out the paperwork and file it yourself. But then what do you want to do? It's like Coco chasing a 18-wheeler. If she caught it, what's she going to do with it?
Right. What do you
do with it?
Yeah, you don't
have it. Just get counsel from the beginning on that. I know the next question is how much does a probate cost? I tell people to plan for at least 10 hours. That's all inclusive as far as the 10K release and stuff like that. And it obviously goes up from there. It depends on if people are fighting or if they're not fighting, how much work's done, how many pieces of property are we going to have to sell? Do we have to sell any, or we just transfer it? And so there's a wide variety there of cost.
And how complicated, just the complication and the size.
Yeah, complication and size and everything, how much time is it going to cost? So,
all right. Well, we like to leave with one thing. Let me pull this up. I've got my collection of country sayings.
Okay.
You said a few.
Yeah.
Let me see. Here's one. I'm going to ask you three, and you tell me if you've heard of them.
Okay.
Hollering distance. How far that is. That's just over, how far
they can hear you.
Yes.
They can hear you, yes. That's a hollering distance.
Have you ever heard, like to killed me?
Yes, all one word. To killed me.
Like to killed me.
Like to have killed me. I've heard that one too. Yeah, that would be usually when you're on a boat with somebody and you hit a big wave, they like to have killed you in their mind.
Have you ever heard wooled as a verb? They wooled that baby to death, or they wooled that kitten.
I hadn't heard that one in a while, but I have heard that one before.
It's like handling or rubbing or, I don't know, fooling with.
Yeah.
My granny used to say, you quit wooling them kittens, you'll kill them, they'll die. Quit wooling them kittens. Or somebody said, they wooled that baby,
Yeah.
So, you got any other ones? Don't step over $1 to pick up a dime. That's a good one.
You really put me on the spot here. I actually have a lot of them, but I can't think of them right now. So maybe we'll have to do another one. You start keeping notes in your phone, and then we'll have one of just country sayings. Okay.
And I would love it if you could incorporate it into things your clients have said. Because when my clients will say stuff sometimes, and I'm thinking, I think I know what that means, but I know what I think that means, and maybe you mean something else, and it's how to not look stupid to them, but also not make them think you don't,
Yeah.
So sometimes people will say things, and it's like one guy told me that his hot water worked, you just had to run it right smart. Okay, does that mean I have to do it right? Or does that mean I have to do it for a while? Or, I think he meant you had to run it for a little while for it to get hot.
Right.
But, so there's always a new one. But we'll reconvene with the country sayings, and especially country lawyer sayings. How about that?
Very well. We can do that for sure.
Okay, thanks so much.
You're welcome. Thanks for having me.